to go ahead and start the second part of the debate for our special election for district judge in Harlan County. To my right, I have Jonathan Lee, who is the assistant Commonwealth attorney. Directly beside Jonathan is Danny Lunsford. He works for the Howard Law Firm. Is that correct, sir? And last down here is Scott Wissenby, who's worked for the Odie Stone Law Firm. All three of these gentlemen, I want to thank them for coming out, and I want to thank all of you. And in the vein of our last debate, let's get ready to rumble.
All right, gentlemen, here we go. We'll begin with opening statements. Kind of appropriate, isn't it? And we'll start with Mr. Wissenby.
Thanks, sir. Good evening, guys. Thanks for coming out. My name is Scott Wissenby, candidate for Harlan District Judge. I'd just like to tell you a few things about myself. I'm a lifelong resident of Harlan, born and raised down in Louisville. I graduated across the parking lot here at James A. in 1994. I went from there to the UK and graduated with my law degree in 2002. After that, I came back home to Harlan County and began practicing law, and that's what I've been doing ever since, mixed in with a little bit of raising a family and a few kids. They're here tonight, and I'd like to thank them for coming out. I've got 14 years of experience. During that time, I've practiced at all levels across the Commonwealth, both state and federal court. In addition to that, I have practiced before the Social Security Administration and the Workers' Compensation Board. Doing that, I fought for hard-working people in Harlan County to get them the benefits that they deserve. I feel that it's my experience that sets me apart from the other two candidates. I've got 14 years of experience, which is more than the two of them combined. Not only do I have the legal experience necessary to be your next judge, I also have the appropriate demeanor. I am humble and I am approachable. I come from a working class family. Growing up, cold put the food on the table with clothes on my back, and I want to thank my dad for that and his service in the coal mines for over 30 years. If elected, I want to make you one promise, and that is to treat everybody fairly, no matter who comes before my court, no matter who they are, where they come from, what their background is. So I'd like to ask you all to consider me on November 8th. Thank you.
Mr. Lunsford.
My name is Danny Lunsford, and I am also a candidate for district judge. I'm from Everett's. I grew up in Milliken Addition, went on to, after high school, Everett's High School, went on to University of the Cumberlands in Williamsburg, Kentucky, and then on to law school at the Appalachian School of Law. And currently I am the managing attorney for the Howard Law Firm in Harlan. I'm running for district judge because I think this is a very important election. We are filling an unexpired term. So unlike most elections, the candidate who wins in November doesn't take office in January, he takes office almost immediately. We need somebody who has the experience in district court. Experience is important, but experience in district court is what's most important when you're running for district judge. For the past almost 4 years now, the bulk of my workload has been in district court, from criminal defense in district court, probate wills in district court, representing the children in defending abuse and neglect actions, and representing the mentally incompetent when they've been involuntarily hospitalized over Great Sidewalk. I do that service, by the way, for free. Mr. Lisby and Mr. Lee are both older than I am. I can't deny that. And in most instances, that's usually a good thing. But I'll tell you this, I think, regardless of their legal experience, I don't think they have as much as I do in district court. And I think that's what's most important when you're looking at district judge, who knows the policy, who knows the procedure, who knows the clerk's office. Nobody is in that district court more than I am. And I am ready to run it for the bench on day one. Thank you.
Mr. Lee.
Thank you. Thank you, everybody, for sticking around for this. My name is Jonathan Lee, and I'm running to be your next district court judge. I'm born and raised here in Harlan. I've lived here my entire life, except for the time that I've gone off to school. I started my educational career, so to speak, here in Harlan at the Woodland Hills Christian School. Got a wonderful foundation there of not only the fundamental educational principles, but an infusion of a Bible-based curriculum. I went to high school, started high school at James A. Kaywood High School, and I finished up at Harlan High School, graduated there, went on to the University of Kentucky, where I got my bachelor's degree. I went to the University of Dayton School of Law and graduated with honors there, and went to work thereafter. Came back to Harlan. This is home for me. I brought my wife, Jennifer, back with me. We've raised our family here. I have 3 wonderful children. We have 3 wonderful children. I won't take all the credit. But we have 3 wonderful children. We love this place. I'm vested in this community, and it means a lot to me. I'm your assistant Commonwealth attorney. I'm one of 2 felony prosecutors here in Harlan County. Mr. Parker Boggs, the Commonwealth attorney, and I work with one another, and I appreciate the opportunities he's given me. I've gained valuable experience there. But I've been a defense attorney. I've had my own business. I've had my own law firm working with the people of Harlan County, and I think it's that experience that separates me from the other candidates. I'm the only prosecutor here. I'm the only one with real litigation experience, criminal jury trials, and I believe that I'm the only candidate that can bring consistency and fairness to the district court office. Thank you.
Thank you, gentlemen. For this debate, we are going to ask you all a question and give you all a chance to respond. And then before we move on to the next question, we will start with Mr. Lissenbein. This question is, no matter who is elected this November, each of you will be required to carry professional relationships forward as one of you assumes the position of district judge. What steps can each of you take to ensure that any conflicts of interest can be dealt with to ensure functions of the district court are conducted both fairly and without undue delay?
The steps that I would suggest we take is to continue on the route that we're on right now. I don't consider these 2 gentlemen opponents. I consider them my friends, and I always have. Jonathan a little longer than Danny, and that's just because he's been around longer. The steps I would take, like I said, Brandon, would just be continue on the steps that I'm taking right now, which is just to continue to treat these men fairly, treat them with respect, and that's the same with them.
Mr. Westbrook.
Certainly conflicts are a serious issue for judges, and I think it's one thing you have to consider is, practicing here for a long time might give you more legal experience, also gives you more conflicts. If you want a judge who actually doesn't have to call in a special judge as much, well, then that won't work in my favor. As far as personal relationships with the local bar, Mr. Lisby, Mr. Lee, I think we have one of the most cordial local bars, but it doesn't prohibit us from adversarially advocating for our clients when it comes to it, and wouldn't prevent me certainly from ruling against any local bar or for them. That's not a consideration that we'll have in place. So I don't really see conflicts as a serious issue really for any of the candidates, but I think it's the least one I'll probably have with me.
Mr. Lee?
I certainly won't have any conflicts of interest with these 2 gentlemen standing beside of me. They're colleagues of mine. We differ on some issues, but there won't be conflicts there at all. I think the conflict issue will be with people who have worked in district court. Mr. Lunsford stated that he's working in district court, and I would agree that the body of work that he has completed as an attorney has been primarily in district court, so we may have several conflicts there. Mr. Lissenby works in district court, as well as Mr. Doan and Mr. Lunsford with the Howard Law Firm. Anybody that is practicing with them, they may have conflicts when they come before them. I will not have any. One of the advantages of being a prosecutor, being an assistant Commonwealth attorney now, my foray into the district court is often with cases that are quickly brought up to the circuit court level through the process of going through the grand jury. They're not there long, so therefore any conflicts that would have existed in cases would be quickly resolved, and I will need ordinarily no special judge to sit for me.
Mr. Lee, we'll start the next question with you and move back this way. Open and accessible courts, being a bedrock of the justice system in our republic, are essential to building the public's faith in our justice system. Excluding instances where a sealed courtroom is mandated by statute, what steps can you take to ensure the district court is open and accessible?
Well, certainly court systems should be accessible to the public. That they are the bedrock of our justice system, and in district court in particular, most law-abiding citizens, the contact that they're going to have with the criminal or civil docket will come through district court, through issues with probate or other matters concerning truancy and things of that nature. District court is the court where most people, if they interact with the court system, they will have to do so with the district court. So transparency, open doors, you know, as you mentioned, there will be certain times when things need to be sealed, but for the most part, absolutely not. It's public record. People who know that, who are familiar with the court system, know that what happens down there, what happens in your district court, for the most part, is public record, and there's a reason for that. You know, people should be aware of what's going on, be aware of what their attorneys are doing, be aware of what their judges are doing, what their prosecutors are doing, to keep everyone down the straight and narrow path that we all should be on.
Mr. Lunsford.
Certainly, just keeping the doors open. In circuit court, we currently have the capability to broadcast what's going on in court on our local channels. I don't know if we have that capability right now in district court, but that would be certainly something I would be interested in looking into to make sure that people, not only just in the courtroom, but from their homes, can view what's happening in the district court and make sure things are being run in a fair and consistent way. But speaking of that, there's one specific issue that I think needs to be addressed. The Supreme Court this year began a pilot program to open up juvenile cases to the public. Right now, those are sealed records. No one has access to them. You cannot come to the courtroom when a defense abuse and neglect action is being heard. The Supreme Court is now looking at opening those up. That is something I would oppose until it's enacted. I don't think a child who's been subject to sexual abuse or neglect or has been physically abused should have those records open for anybody to come in and listen to. So if you elect me as your next district judge, it's one thing I am going to fight for towards Chief Justice and the justices before they make that a statewide program to not allow that in Harlan County.
Mr. Lispy.
Thank you. I think in order to maintain a fair court, it has to be open and accessible. You can't be hiding behind closed doors and having the proceedings going on where nobody can have access to them. You want to, if it's a public day, if it's a jury trial day, such as that, where it is public knowledge and public record, open the doors, let anybody come in that wants to and see how everything's going, see how the judge is working, see how the county attorney is working, see how the defense attorneys are working. Let them watch the jury trials. Whatever people have an interest in, the doors are never locked, people can come in. I'll touch on what Mr. Lunsford mentioned. That was Senate Bill 40 that was passed back in April of 2016 when the governor signed off on it, and it is before the Supreme Court in a pilot program. It doesn't include sexual offenses. Those are under that, they'll never be public record. And it leaves a great deal of discretion to the individual judges to determine what about children you can release. In my opinion, I don't think anything should be public record in regards to children because you're dealing with their ages, social security numbers such as that. Those are filled out on those forms, and I don't think that should ever be public record.
Mr. Lispy, we'll begin the next question with you. Everyone on the stage possesses the qualifications outlined in the Kentucky Constitution to be Harlan County's next district judge. What qualifications and what character traits do you possess that make you more uniquely qualified to be judge?
Thank you. I just go back to my opening. I've been practicing, I've got more years practicing than the other two put together, and that's not knocking either one of them. I'm just stating the fact. They can differentiate if they want to between, well, this experience matters and that experience doesn't, or I've got more experience in district court than them. And that may be true for the last 4 years, but I've still got 14 years, and in those 14 years, I've got more than his 4 years of experience in the district court level. Everything that they've talked about doing in district court, I've also done in district court, and continue to do in district court. I practice pretty much equally between district and circuit courts now. And like I said, I've got 14 years, which is more than the other two put together.
Mr. Lunsford.
I think where you have your experience is incredibly important when you're running for a specific office in a specific courtroom. District court is very different from the circuit court. The circuit court is a court of equity where things are very more general. You draft your own orders, or you can have the attorneys do that. In district court, everything is on a form. It's on these AOC forms 54 and AOC form 55. And as your district judge, I'm not going to have to look to the clerk and say, what form does it go on, and what boxes do I check? Because that's most of what the district court forms are, because I do those on a constant basis. And let me touch on real quick on Mr. Lee's point that he thinks I might have more conflicts because of my district court work. I think as a prosecuting attorney, if you're prosecuting 1,500 people every year, you might, whether it's a legal conflict or not, it might be perceived as an actual conflict of interest when these same defendants come before you as district judge. My experience doesn't work against me, it works for me. It's what makes me the most qualified candidate for district judge.
Mr. Lee?
Yes, I think that's a good example of how experience matters. Conflicts are stated out in the Kentucky revised code, the statutes there, and it specifically spells out what a conflict is, and my conflicts are part of my my work as a prosecutor would not lead to conflicts in district court simply because I've prosecuted someone. In terms of experience, I think it matters what you've done, not how long you've been doing something. I worked with the Kentucky Department of Natural Resources before I went to law school. I'm 35 years old. Mr. Listenby's 40. He's got 5 years on me. But in my career, I'm proud of it. I stand on it, and I think I've done a lot. I think it's important to have seen both sides of issues. I've been a prosecutor. I'm a special assistant attorney general and a special prosecutor throughout the state, primarily with violent crimes in multiple districts, multiple circuits. I've had my own business and as an attorney. I've been a defense attorney. I've worked as the attorney for the city of Cumberland. I stand on my record. I think it's experience that the other ones don't have, and I think it's important experience, and that's why I think I'm set apart as the appropriate candidate for district judge.
Mr. Lee, we'll begin the next question with you. What, in your opinion, is the proper way to balance the enforcement of local and county ordinances fairly and equally without becoming a burden on our citizens?
Well, enforcement of ordinances is a matter of law. I think that, when ordinances are enacted by any type of public entity that are lawful, they are thus enforceable. So I don't know if you can get into picking one over another. I'm going to enforce this one this time. I'm going to enforce that one that time, not this one here. I think that's a matter that's left for the legislature, the legislative branches, which would be in local ordinances, the city councils and things of that nature. But when those come before the court, which the district court does have jurisdiction over those matters, and they're sent there to be enforced, I think that that's something that a district court judge has to look on a case-by-case basis and see what's right, what's fair, what the law says, and follow the law. We can't prejudge issues, and I won't do that here. But I will tell you that I will follow the law. I will enforce those ordinances that are lawful, that have been voted in appropriately, and that the communities here stand behind.
Mr. Lunsford.
I would echo Mr. Lee's sentiments. Certainly the only times a local ordinance or enforcement issues will come before the court is when the county attorney brings it before the court. The district judge is not going to have any real leeway in what issues to come before the court. But the district court does have an important role and it can affect the county, and particularly the budget of the county, in a very important way. The district court can send people to jail on a consistent basis. In one particular issue, when someone owes fines to the court and they don't pay those fines for a certain date, typically the response is hold them in contempt, throw them in jail, and sit there until they pay it. But that costs money. It costs money every time you put somebody in jail. You have to feed them and provide their medical care or whatever needs they need. There are other tools the district court can use, and I'm certainly ready and able to use those tools, such as giving people the opportunity to work it off the whatever fines they have at a community service through a local church or the animal shelter or poke salad festival or something like that. That way it relieves the burden on the county as far as incarcerating the people, but at the same time people are still being held accountable and punished for the crimes that they commit.
Mr. Listenby.
With regards to local ordinances, I'm assuming we're talking about something as far as city ordinances passed by local city government. Those are written, being an attorney for the city of Loy and the city of Harlan for the past approximately 8 years, I've written several of those ordinances. And the way those are generally written is you provide your own penalties in there, and it's enforceable usually under review by the city council. And if the city council doesn't make an appropriate resolution, the person feels aggrieved with that, they can appeal it to the district court. That's typically how those work. If something of that nature came before the district court, then I would abide by the ordinance as written by the city. Assuming that that ordinance was written lawfully and was constitutional, those are things you would need to review in that regard, just to make sure that it wasn't overly burdensome on the public. That's all. Thank you.
Next question, starting again with Mr. Listenby. What steps within the boundaries and limits of the law can district court take to curb the county's ongoing problem with drug addiction and crime that flows and follows, in some instances, from alternative sentencing, deferment, and drug treatment programs?
That's a great question. And actually, I've spoken with one of our neighboring district judges as well as with the administrative office of the courts about the possibility of getting a drug court for the district court here in Harlan County. We've got one in the circuit court. I think it's had some great results. And I have spoken with people in regards to getting that set up in Harlan County. We can provide treatment, alternative sentences to those folks who qualify for district court, drug court. In addition, we can maybe provide jobs in the form of drug court workers. We would be able to work with the community, local pastors, law enforcement, educators, to see what kind of help these people need and get that to them.
Mr. Lunsford?
Certainly, in addition, I'll be open to an opening of a drug court or district court, but as Mr. Lisenby said, that requires AOC funding, state funding. It's not guaranteed. Another option that we have that I'm ready to institute is a private program to allow people to be supervised while on probation. Currently in circuit court, when someone's on a felony charge, they are supervised by the Office of Probation and Parole. The state doesn't offer that to misdemeanors. Those are only convicted of violations or misdemeanors. But the law does allow the district court judge to set up a private program that's paid for by supervision fees from the defendants themselves who have been convicted to institute a supervisory probation program to actually put actual requirements on them when they are on probation, such as drug rehab or whatever it may be, and be supervised by this private program. That program will be completely funded by the supervision fees themselves. I can have that instituted, my hope, by January 1st, 2017, if you let me as your next district judge.
Mr. Lee?
Yes, first off, with drug courts, it's my understanding that drug courts are primarily, at least for the AOC, for felony offenses. As assistant Commonwealth's attorney, I recruited the IOP program here at Harlan, the intensive outpatient program as an alternative to sentencing with the drug court program for lower level felonies. I think that type of thinking outside the box, bringing things in, is what you have to tailor these probation and diversion agreements to each individual person. And that's what we need. It's common sense. You need to tailor these agreements for the individual before you. That means if someone's not paying child support, send them to work. If somebody's addicted to drugs, send them to drug rehabilitation. Put the conditions upon that person that is specific to them to make it worthwhile. It can't be cookie cutter. It can't be something that you just put everybody in a box and do the same thing. You have to have in-depth commitment to reaching each individual person and work with all of the assets at your disposal. It's a tough problem with not an easy answer, but it begins with individual assessment of defendants.
Mr. Lee, we'll begin the next question with you. District Court, being the branch of the court system in Kentucky that deals with juveniles, stands on the front lines in regards to juvenile offenses. What can you do as district judge to ensure that our district court can be a second chance for reform without becoming a revolving door? And the same question can also be asked for adults.
Okay. You're speaking then there's something concerning recidivism, and that's the relapse of criminal conduct by a person that has been convicted of a crime and then thereafter goes back to a life of crime within 3 years in Kentucky. You know, that's something that's plagued both the circuit court and district courts, and there have been bills passed, House Bill 463 and 200 for each respective system, both adults and juveniles, to come up with what we've been talking about, alternatives to what we've always done. The answer is not always put them in jail for as long as you can, because prison sentences are a fiction. You give someone usually a 10-year sentence, they're going to serve 1.5 years. You give someone who's addicted to drugs a 1-year sentence or a 12-month sentence, you know, let's speak 1 month, they may serve a period of months. And if they've been addicted to drugs for 20 years, 6 months isn't going to do much. You have to tailor all of your resources to that individual. Your conditions of probation, send them to school. School works, jobs work. Try and mandate that these individuals go to school, finish their GEDs, and get into jobs so that they can bring themselves above the old system and do more with what they have.
Mr. Lunsford.
About 2 years ago, the juvenile justice system was overhauled in Kentucky, and the main goal of the juvenile justice system when the child is charged with any kind of criminal offense is to do what's in the best interest of the child rather than pure punishment. So that's certainly something that we have to abide by as a district judge. One issue that, in particular, that I noticed in the juvenile justice system is our schools need to start taking responsibility for punishing our kids for certain things. I'll give you an example. About 2 years ago, as a district court, a child appeared before the court charged with disorderly conduct for texting in class. That is utterly ridiculous. Schools need to keep We don't need criminal records for adolescent behavior. When you come to court, that should be a court of last chance, not a court of first opportunity. These kind of cases will not fly on a district judge. If it's something like that, the school systems want to start taking responsibility for those kind of cases.
Mr. Lisby?
Thank you. I think what we need to do to address the problem with repeat offenders such as that with juveniles, specifically with juveniles, is you need to get to what the heart of the problem is. You need to take these kids, you need to look at their families, and you need to see what's going wrong. Taking my daughter into school every day, I see kids, and you'll see them, and they all kind of start out the same. They're smiling and happy, and as the years go on, you'll catch a few of them that disappear. They're not smiling and happy. These are the kids that will end up in juvenile court. These are the kids that we need to get a hold of while they're young to break this cycle of drug abuse, to break the cycle of truancy, to break the cycle of dropping out of school as soon as you can so you can go home and mommy and daddy can not have to worry about sending you to school anymore. Parents need to be held accountable. I agree with Mr. Lunsford. Schools need to be held accountable. Everybody needs to be held accountable because these are our kids and our future that we're talking about. And I think that is the priority of district court, and that would be my priority if elected as children.
Mr. Lisby, start the next question again with you. In a county as small in population as Harlan County, almost every practicing attorney knows and is familiar with each other. What steps can you take to ensure the practice of ex parte communication doesn't take place in your court?
You're exactly right. It is a small bar. As we've all stated up here, we're all colleagues, we're all friends. I can say that about practically everyone in the bar. I think what you do goes back to the question you're talking about having open door policies. You do things out in the courtroom. You don't have a judge and 2 or 3 attorneys filing out of the back room when the court goes in session. Everybody comes in the back door where they're supposed to, where the public enters. You don't have meetings behind closed doors before court starts. You don't leave the public locked out for an hour or 2 before you bring them in and everything's already worked out. So what I think you have to do is make everything above board, make everything transparent, out in front of the public, in the courtroom, and that's where everything takes place.
Mr. Lunsford?
I would concur with that. Ex parte communications are something that, as district judge, I'm not going to allow when it comes to court cases. If my fellow bar members want to talk about a get-together or something with the Harlan County Bar Association, I'm more than happy to talk with them about that on the street. But they're talking about the case, it has to be in the courtroom, on the record, with the record actually going. That way there's a record of it, and if there's appeal later, that record is preserved. Records are vitally important in district court cases and circuit court cases. For every case that the court hears, there has to be an actual record that can be appealed on, that the evidence is there, what was said, what was not said. It's a personal issue because it saves you from any kind of appearance of impropriety or judicial misconduct. But at the same time, it's also important for the defendants and for the plaintiffs and for all litigants before the court. That way they know exactly what's happening. A transparent court is what our judicial system is designed. That's why it's the best judicial system in the entire world, because it is so transparent, and I'll make sure that stays that way.
Mr. Lee?
Yes. Ex parte communication, it's a fancy way of saying talking to one side of a dispute without having the other side there with you while you're talking to them. And it's as bad as running a play against an offensive play with no defense or throwing a pitch with no bat. It's not fair. Common sense tells you it's not fair. And the Supreme Court has simply said we forbid it. There was a case in 2012 that came out where they were having difficulties in Louisville with ex parte communication, specifically in district court, and they wanted to clarify what's the Supreme Court stance on ex parte communications, and it was specifically dealing with the issue of bond after the initial setting of bond, and they said we forbid it. Now there are times when ex parte communications are appropriate, and they're only in emergencies, and you better be able to explain what that emergency is, but the rules allow for it in very limited situations. But how do you stop it? Simple. You don't do it. Stand up, and if people come in there and want to do it, from the very moment you get in there, say, we're not doing that, we will not do that here, we're not going to take part in it, we will not have ex parte communications, and that's that.
Final question, we'll begin with Mr. Lee. Often being the felony arraignment court in Kentucky, district court deals with certain serious crimes before they are bound over to the grand jury or sent to the circuit court system. What can you do as district judge to ensure the most serious offenses, for instance, high-level drug trafficking, violent crimes, crimes of a sexual nature, and public corruption, are not pled out?
Well, I tell you, as a felony prosecutor, this one's easy for me to answer because I have a vested interest in it. You better not be doing anything as a district court judge on high-level felony crimes because you have no jurisdiction to do that. And if you do, it's unlawful. Only a prosecutor, and at that, a prosecutor that has jurisdiction over felony crimes can dismiss a case, move to dismiss a case, and at an arraignment process. It needs to go through the appropriate levels, arraignment, go through a grand jury process and get into the jurisdiction where the court can oversee it, the prosecutors can deal with it, and the defense team can then do what they need to do. You know, there are very limited ways to dismiss a case absent a prosecutor's agreement. It has to be basically fraud, some type of criminal activity in part to the charges. So absent that, I tell you what I'll do. I'll send them up to the district court or to the circuit court if they need to be, and I will state that there's no probable cause if that's my finding in a preliminary hearing if we go that way. But in terms of keeping them in district court, you can't do it. You don't have jurisdiction over it, and if you try to do that, it's unlawful.
Mr. Lunsford?
And that's entirely correct. District courts don't have jurisdiction over felony offenses, barring preliminary hearings, which is only a hearing to find if there's probable cause in the grand jury. And quite frankly, the preliminary hearing stage of district court is really antiquated and really not useful, waste of the court's time. Even as district judge, I find there's no probable cause. It doesn't prohibit the Commonwealth from presenting the case to the grand jury anyway. So it's really a waste of time for the court, and I think the legislators should change that particular function of the district court. But when we're talking about plea deals with misdemeanors, I think too often, both in circuit and district courts across the state, the judge's office believes that they are merely a rubber stamp for the prosecuting attorney. If the prosecuting attorney agrees with, or even if the defense attorney wants to put forth a plea deal, it's not the judge's job just to rubber stamp that. We need to look at the actual plea deal, look at the defendant's history, and be willing to say, I'm not accepting this plea deal. It is not harsh enough, or it's not lenient enough, whatever the case may be. I will not be a rubber stamp for the county attorney. I will not be a rubber stamp for any of the defense attorneys. I will have no problem whatsoever in denying a plea deal and saying either take it to trial or work out a new deal.
Mr. Lispy?
Yes, in regards to felonies in district court, they're only there for a very limited amount of time, and that's only at the preliminary hearing stage of the game. And that's simply where you come in and you see if there is probable cause to bounce something over to the grand jury. And what that means is if you've got somebody accused of a felony and they come in before your court, you see if the officer that's there on that case has enough evidence to say it's more likely than not that a crime occurred. If you find that it's more likely than not that a crime occurred, you're done and it goes to the grand jury. If you find that it's not more likely than not that it occurred, then you can dismiss it. So that's really the only time that felonies get into play in district court, and that's the only function that district courts have.
That was the final question. We're going to move on now to your closings. And we begin with Mr. Lee.
Thank you all. I appreciate the time here. I appreciate the time to speak with you and talk about myself. And we'll go back over the things I said in the opening. I'm the Assistant Commonwealth's Attorney. I'm a Special Assistant Attorney General and a Special Prosecutor throughout the state. Before that, I was a defense attorney. I worked with the Department of Public Advocacy. I had my own business as an attorney doing various civil lawsuits as well as criminal lawsuits. I worked as the attorney for the city of Cumberland for a period of years, and I'm proud of that service. And I think that the things that I've been able to do, both as a prosecutor, a defense attorney, and as a private attorney owning my own business, distinguish me from the other candidates here. I don't think that it's length of service. I've practiced from the district court in Harlan to the federal courts of this nation doing a variety of things, but I've gained experience that other people don't have. I mean, it's simply true. Prosecution is a wonderful thing. It's rare to have, and I think having experience on both sides, both as a criminal prosecutor, defense attorney, and as a civil plaintiff's attorney and defense attorney is necessary when you're running for a district judge to be the referee, to be in the middle of these issues. I thank you for your time, and I appreciate your vote on November the 8th. Thank you.
I'm the youngest candidate in this race and the one that has been licensed the least amount of years. Though I think having the least amount of hair should give me some bonus points. We live in a country where you can be 35 years old and be president of the entire United States. Don't hold my age against me. I have been in the district, it's not just the amount of years you have, it's what you've done in those years. I have been in the district court more than either of these candidates. I know the policies and the procedures better than either of these candidates. I know what's worked well in the past, and I'm ready to continue on those practices. I know where it can use improvement, and I'm ready to fix those on day one. You won't see me on the bench asking the clerk, what do we usually do here? Where is this form? What happens at this stage? I already know it. I'm ready to be your district court judge on day one. I will run that court competently and for you. The law will be abided. Favoritism will not be allowed. We will have a district court that works for Harlan County.
Mr. Elizabeth?
Thank you. Again, I want to thank you all for coming out. It shows a lot on all of you to come out and stand here and watch us candidates and the candidates before us. It means that you care about your community, you care about your county, and I commend all of you for that, coming out and spending your Tuesday evening with us. I want to thank my parents that are here, Bill and Ann, listen to me. I want to thank my wife, Tanda, and my kids, Hunter, Ella just grinned at me, and Deacon. They've been my support and they've been my rock, and I thank them for that. We've heard a lot here tonight about the problems Harlan County faces. The one we've heard the most undoubtedly is about drugs. We heard before that about the loss of jobs and the loss of coal. It's no secret we got problems, folks. We do. I'm not going to sit here and tell you I can fix them all from district court. It's not going to do it because I can't. Nobody else can either. But what I will tell you, and what I will promise you, is that I'll be fair, I'll provide stability, and I'll give you someone in the courthouse that you can be proud of, and I ask you for your vote on November 8th.
Thank you, gentlemen, for participating in tonight's debate. Thank you all for coming out. Good night.